what to consider in your trustee or power of attorney powers. Different states have different laws. In Washington, if you want to grant certain legal authority, you have to be very specific about what authority you're granting. And why is that? Well, the authority for your trustee, who is not you, or for your power of attorney, that document, you appoint an attorney, in fact, is what they're called. Both of them are called fiduciaries. Their job is to carry out what your wishes are as stated in the legal document. So let's first focus on the trust document. The trust document can grant very minimal authority to your trustee. For example, your successor trustee. Gifting authority. Do you want to give your successor trustee the ability to gift out everything in your trust? Or do you want to say that they're limited to the annual exclusion amount? Or do you want to say they have no gifting authority at all? That, and the same holds true for a durable power of attorney. Are you going to give gifting authority, for example? Well, to answer the question about whether that is appropriate, we need to know what your situation is. Do you have a taxable estate? In Washington, for example, if you have a taxable estate, we definitely would want to give gifting authority to make sure we avoid any kind of Washington estate tax. So it makes a lot of sense. On the other hand, let's say you don't have a taxable estate. In Washington, that's $2.193 million. Let's say your estate is $500,000 and $300,000 is your house and $200,000 is your bank accounts. Well, you're not worried about an estate tax, but what you might be worried about is all your money going to pay for your care at a nursing home. So as an elder law attorney, we likely are going to put in our powers of attorney broad gifting authority to the extent that your attorney, in fact, can gift out all your assets if it is for the purpose of qualifying you for Medicaid, and if an attorney puts in writing that this is the plan, this is not going to cause any harm to the principal, to the person who we're gifting their assets away. In fact, it's going to benefit them, it's going to accomplish their goals, it's going to preserve their assets, their estate through this gifting. The state will pay for their care. How does a lawyer know that? They only know that if they have met with the person, they understand what assets they have, what their health is like, what their goals are, what their family dynamics are, whether it's appropriate, and that attorney is willing to stand behind any authority that's been granted, particularly when it comes to Medicaid eligibility. So there is no pat, easy answer to how much authority you should grant. What you should do is speak with your lawyer and make sure that you understand why authority is included or is not included, and is it right for you.